By way of introduction, my name is Nicola Billen. I'm one of the partners here at DMH Stallard. I've got here today Abigail Maino, who's one of my fellow partners at DMH Stallard, and also John Douglas, who's from First Response. What we're going to do today is talk you through a number of issues regarding protecting your business assets. Next slide, please. Thanks. So, as you can see, Abby is going to be talking about how you can protect your company's confidential business information and assets both during employment and after your employee leaves. Then I'm going to move on and talk a little about what steps you can take if something goes wrong and it looks like your competitive advantage has been compromised. Then John's going to talk about the forensic side of all of this. He's a specialist in that area, and he'll be talking through how you can prepare for and respond to a leaver who might decide to steal your sensitive company data. And after that, we'll have Q&A. Now, can I please encourage you to write any questions that you might have, any at all, in the Q&A box, and we'd be delighted to pick those up afterwards. Equally, if you've got any problems with hearing us or any problems during the presentation, please put that in the chat box, and a member of our IT team will be able to help you. So I'm going to hand over to Abigail Maino, who will talk you through protecting your business assets.
Thank you, Nicola. Good morning, everybody. Yes, so I am going to talk for about 10 minutes or so on protecting your confidential business information and assets during employment and after your employee leaves. So it's a relatively short time, and what I'll cover is some of the protection that is automatically implied into employment arrangements, the limitations of that and the benefits of different types of written terms, and finish with an overview of restrictive covenant types and some fundamentals to think about to get the best chance of enforceability if you need to. So what's protected automatically? Well, the law does provide some protection without any specific written terms, but they're fairly limited. So all employees have an implied duty to conduct themselves with fidelity and good faith. And what this means is that there's an implied duty that they will act honestly towards their employer, that they will disclose information that's relevant to their employer's business, that they won't make secret profits from their employer's business, and they will respect the confidentiality of commercial and business information and not compete with that the employer's business. And this duty is implied into all employment relationships, no matter how senior the employee is. So there's some protection that automatically arises. The extent of the implied duty of confidentiality will really depend on the type of information involved. So information that an employee is expressly told is confidential and which is obviously confidential as a result of its character is protectable without any specific written terms. But because that's often open to interpretation and attack, we would always suggest that employers specifically protect their confidential information with written terms, which I'll come on to. Directors are obviously clearly more senior within the business and have additional fiduciary duties. And these are specific duties that they have by virtue of their status and role within the company. And as part of that, they must act with in best interests of the company and not do anything which will harm the business. Now, these fiduciary obligations are much more onerous, and a court will hold fiduciaries to a much higher standard when considering whether there's been any breach or harm caused during their directorship. And as part of their fiduciary obligations, they have an obligation to protect and preserve the company's confidential information. After employment, things are quite different. Unless the information amounts to a trade secret, there won't be any protection that a business can rely on. So express provisions are really important in this context. Fiduciaries can, if they act in breach post-resignation, on occasion be liable, but it's not a position that a business is going to want to be in, and post-employment protection without any specific written terms is really quite limited. So certainly we would suggest written terms. So moving on to written terms, the benefits of them clearly is that you can have absolutely spelled out in clear and unequivocal terms what it is you consider to be confidential, what you're trying to protect, and you can really scope out what protection you need. That can be a great thing. It can also be not so great if you aren't clear enough and you don't widen your scope enough. And I'll give you an example of that, and a case in which a director's service agreement provided that all information that he acquired during his appointment belonged to the company, shouldn't be disclosed, and should be treated as confidential both during and after employment. So far, so good. After the director left, the company said, well, look, it's clear that all of this information you have is confidential, please give it back. And he said, no, I'm not going to give it back. And the court said in that case that because there was no express term to require him to return the property, that couldn't be implied into the contract. So it's really important to make your scope clear in terms of your contract drafting from the outset, because falling back on implied terms can have its limitations. Layering up your protection with different types of written terms is really, really helpful in terms of protection of your assets. So it's really important to have an IT policy, an acceptable use policy, what employees can and can't do when they are accessing your IT systems. Have that in a policy, and importantly, make sure people are aware of that policy. And also your stance on personal devices, what can be sent to personal devices or not. Clearly, your confidentiality provisions in your contract, so what's confidential information, and that they can't use it either during or after they leave employment, that they must return property, going back to that case, having that express provision that they return property. And garden leave is another really important, it can be a really important tool when you are thinking about preserving your assets and your confidential information. If you consider there's a risk for an employee who's resigned, having them on garden leave, although as a cost to the business because you're still paying them during their notice period, keeps them out of the market, keeps them from contacting customers or other employees. And they're also importantly still an employee, so they've got those additional duties of fidelity, if they're a director, fiduciary duties. So if they do anything whilst they're on garden leave that impacts adversely your business, it's much easier to go after them whilst because they're an employee than it would be once they've left. So garden leave can be a really important tool in your armoury. And post-termination restrictions, they are useful in terms of setting out what an employee can and can't do. And I'll talk about that a little bit more now in a second, sorry. One thing I did want to put at the bottom of the slide is that think before you dismiss. And that's just a bit of a health warning, really. Sometimes if an employee looks to have done something, say they've, there's a potential they've forwarded an email to their personal device, or they've done something that you think could be a dismissible offence. It's always worthwhile really having a look into it and seeing whether there is any explanation before dismissal. Obviously, you've got to weigh up tipping them off. The risk of dismissing summarily, so without notice, if it's not a fundamental breach of the contract, is that the employee could turn around and say, well, you've breached my contract, therefore all of the other protections within that has fallen away. So your post-termination confidentiality and restrictive covenants. So acting in haste can sometimes lead to issues with with them relying on those business protection terms you have. So I just thought I'd put that up there as a bit of a health warning, to really kind of think about things, maybe consult your lawyers or before you decide to take any action, particularly if you think you're going to want to rely on some restrictions afterwards. Moving on to restrictions, you're no doubt all familiar with different types of restrictive covenants, so I won't spend too much time on this slide. I think the final point on that slide is the important one to consider. Restrictive covenants will protect one or more of those final sub-bullet points on the slide, and that's what you've got to have in mind when you're thinking about what it is you're trying to protect by having those restrictions in your contract. So are you thinking you need to protect your trade connections and goodwill, so maybe for your non-solicitation? Is it your confidential information that's critical here? And that could be with the use of a non-compete and saying, actually, you can't work for a competitor in any capacity, not even going from a salesperson to an admin person, because actually you've got so much confidential information in your head that even working for a competitor in any capacity is going to be a risk to us. Is that what you're trying to protect? Or is it the stability of your workforce for non-solicitation of employees? It may be more than one of those, but it's going to be one of those. And that's when you're thinking about the drafting of it, have that in mind when you're putting your covenants together. In terms of restrictive covenants and some fundamentals, just moving on to the next slide, we've just spoken about what you're trying to protect. Really think about that. Restrictive covenants are really useful to stop an employee doing something for a certain amount of time, but a court, if you're trying to enforce it, will want and expect you to be clear as to what it is you're trying to protect and how long you need that protection to be. So going back to that example of a sales manager, if you're trying to protect your trade connections, your customers, how long is it going to take you to put someone else in that relationship and shore up those relationships? And if it's 6 months, then don't have your covenant for 9 months. Get your contract signed. It's really important that you evidence some consideration in a contract, and it can be really disappointing at the back end when you're trying to enforce what is a great covenant in a situation where you could go after someone and you haven't got a signed contract, because that can be fatal to a case. Don't forget that restrictions are looked at in terms of their enforceability at the time that they're entered into. So if you are recruiting a junior salesperson, to keep on with my sales analogy, expecting them to become the sales director at some point, don't give them restrictions at the start that you would give to a sales director, because they're not going to be enforceable. When that person moves up and gets promoted, look at the covenants and whether you need to change them to make them longer or slightly different, depending on the impact of that role change. And importantly, if you're changing contracts and restrictions while during employment, make sure there's some consideration for that. So make sure you're giving it in return for a promotion and that pay rise or some other term. There must be some consideration when that individual gets the new contract. Otherwise, there is a real risk that you won't be able to enforce that at the back end. So that was a real whistle-stop tour, and I'm going to hand over to Nicola now to talk about what steps can be taken if things start to go wrong.
Great, thanks very much, Abigail. That was brilliant. A really helpful guide to what you need to think about at the start and when you're employing employees and bringing them on board and into the company. So now I'm going to go through what steps you can take if something goes wrong and your competitive advantage is compromised. So I'm going to be looking at what you need to do when it looks like an employee has taken your confidential information, what you specifically need to look for and who you should involve in that process, and then what remedies are available to you. So what do you need to look for when an employee seemingly has stolen your confidential information? First and foremost, I'd suggest look out for signs, because they will be there. There'll be alarm bells on what the individual is saying or doing. Look at social media, because that is a classic example. When people are leaving, they might put things on there that trip them up slightly. So it's always worth having a look at different social media platforms. Also speak to their colleagues. They might know what's going on or what the individual intends to do. You might find that they're bragging to their colleagues about what they're going to do next. So they might be suggesting they're going on to bigger and better roles, better remuneration with a competitor, etc. They might be very down on the company and very uncomplimentary about how they've been treated, or that they're leaving due to a toxic culture or a bad salary, etc. And they might be one of a number as well who've resigned in quick succession, seemingly without cause, and they're all trying to be friendly as they leave, trying to slip under the radar. Or you might just find that something doesn't smell right. Now, the first and foremost thing I would suggest is do not confront the individual and stay calm. If they're still an employee, that could only lead to denial, claims against the company, and then bigger issues for you all. If people are intent on taking confidential information, they often think that they're being clever, although always invariably get caught out. So for now, you just need to keep everything very much under the radar. Now, if they're an existing employee, by all means, carry out your exit interviews if they're still there, but most likely you might find out that they've taken this confidential information once they've left. If they are still an employee or you have concerns, please make sure that you're not giving them what I'd say is the keys to the kingdom. Don't ask them to look through confidential information and client lists, for example, that they might not remember or have day-to-day access to in order to effect a handover. Keep any of those details to a bare minimum, and maybe help the business by just running through that in a face-to-face meeting rather than asking them to complete a document. I've seen it time and time again where the business wants to make sure that their clients and contacts are shored up and that they know how to deal with them moving forward. And they hand over beautiful lists of these people with all of their contact details, names, addresses, telephone numbers. And if the individual is intent on taking that information, that's a real gift for them. You need to make sure that you act quickly if you have any concern. Please don't wait or delay in the process. This is your confidential information and it could already be in the hands of your competitors. Getting lawyers on board straight away to help talk you through the process and start an investigation into what's happened is key. And then they will be ready to act quickly if needed. Now, I'll talk more about that later in the remedies section. But the key to protection is not procrastinating if you want a court to help you as a matter of urgency. Have a careful look as well at what the employee has access to. So you might have confidential information on central drives, you might have hard copy Bibles of information, pricing, etc. Make sure that they don't have access to that anymore once they hand in their notice and severely restrict it. But start to look at what they did have information to and gather your evidence quickly and quietly. So moving on, what do you specifically need to look for and preserve, and who should be involved in the process? You need to make sure that you obviously involve key personnel, and I would suggest obviously your HR team. They are going to be key in pulling together the contract, any amendments that there have been to the contract, any key policies around computer use, data protection, etc. Involve the line manager of the individual in question. So if they are still an employee, they can at least keep an ear and an eye out for what's happening, and they can report on any handover meetings and discussions that are taking place. Involve the SLT and key decision makers within the business so that if you do need to move quickly, they fully understand what's going on and can make a decision straight away to act. Your IT team as well are obviously vital to this process. They can access important information and make sure what you need in order to prove your case can be preserved. Speak to key colleagues as well, only on a need-to-know basis. But if you think that they can attest to what has happened, what has been taken and what's going on, then involve them at the start. And your lawyers, having them on board, will be able to take proofs of evidence from those individuals and make sure that they are statements that you can rely on in court if needed at a later point. Speak to ex-contacts and clients of the employee if you can. Don't do it in such a way that it seems obvious that something might be happening, but perhaps check in with them, see if they've been contacted. look at whether they might have left or be leaving or might be complaining and making noises about going elsewhere. So what needs to be preserved, and John will talk about this in a little more detail as part of forensic readiness. But again, I'll go back to the point that preparation is key, and gathering your information and making sure that you've got adequate retention policies in place. I couldn't tell you how many times we've had issues where an employee's left. We know they've taken something. We know they've taken confidential information, but the company has policies where email records are wiped the minute that they walk out the door and print records aren't kept. So I would strongly suggest that you make sure that your retention policies are such that your email records are kept for a good period of time so that you can go back and check them and see what's happened if needs be. Also your print records, any telephone logs, if calls are recorded or if there are logs of conversations with key clients and customers. Look at any notes of conversations as well that happen between HR and the individual, line managers and any other colleagues. Keep logs of access to specific drives and information. So have you got pricing lists, client lists, business plans? Depending on the type of business that you are, you might have drawings, computer programs, inventions, formulas. The list of confidential information goes on, but see if you can keep logs of who's accessed what and when. Keep records of clients and contacts if they are leaving and why. Keep notes of the emails that they are sending or notes of any telephone calls, because that might be anything that points to the wrongdoing of this employee. So moving on now to what remedies are available if a problem does arise. Now, a very, very serious remedy, and if you really think that your confidential information has been taken and you are desperate to stop it from being published, is to seek an injunction from the court. Now, this would be an injunction that's called without notice, ex parte, which essentially means that you go to the court without the ex-employee knowing that you are doing so. In order to succeed with such an injunction, it has to be made without delay and before the information has been used in breach. You need to show the court that there's a serious arguable case to be tried and that damages would not be an adequate remedy. So what that means is, ordinarily, if you have a claim against someone, you bring a claim for damages for the losses that you have sustained as a result. But here you would say that is not enough. We need an order from the court to stop this information being published, to stop this information from breaching their restrictions and from going to competitors and from going to our clients and customers. Because if we don't stop them, it's going to seriously damage the business. And this is where evidence is key. So you've collated everything and you've got your right policies and processes in place to allow you to do so. You've got a strong contract of employment and you've got great restrictive covenants, as Abby's talked you through. That's really going to help you here. You need to show the court that the company would suffer the greatest prejudice if the injunction wasn't granted. Now, this is what's known as an equitable remedy. So that means that the court needs to look at what's fair and make sure that the company is acted properly and quickly. And for any injunction to work, you as a business need to come with clean hands. So you need to be doing the right thing. You also need to provide what's known as a cross undertaking in damages. And what that means is, if the court were to order an injunction, and if you're wrong about the claim and they've made the order, you're confirming that you would be able to pay any costs or losses associated with the individual if that order is wrong. So if you get your injunction at that stage, what the court will do is it'll award an interim injunction, which will essentially preserve the status quo, and it'll keep it in place until a further hearing. There will be a trial on the merits of the case, and then a final order will be made, hopefully in your favour, if you have the evidence to show the wrongdoing of the individual. Now, as part of the injunction process, you can apply for what's known as a search order, and these are interesting. They're not cheap to get, but then neither is an injunction. But it is where it's absolutely vital to protect the business interests. What a search order is, and where it's very useful, is where there's a particular concern that the evidence might be destroyed. I had a case on this where a number of employees left together, and we sought an injunction, but what we did for a period of time was had a private investigator that looked at where all of the ex-employees were going, and they'd set up a business. And then we realised that there was a lot of confidential information that had been taken. So we were able to apply to the court for a search order, and we were able to go in and seize computer equipment which held all of the confidential information of our client. Now, when you're making and applying for a search order, you need to consider carefully what documents and items to include in that order and what format they may be held on. So are they in electronic copies or are they in hard copies? Because that will need to be set out in an order. So if it's not absolutely crucial to stop the individual without notice, and you think perhaps that they've already used the information, so for example, you're being contacted by a number of clients saying, we're fed up with your service, we're moving to Joe Bloggs, who's the ex-employee, we're moving to their new company. That will set off alarm bells in your head and make you think, hang on a minute, this individual's taken some information because they're obviously contacting our clients and customers. Then you can send what's known as a cease and desist letter. Now, essentially what a cease and desist letter is, it's a letter written to the individual saying, here's a reminder of the terms of your contract of employment, any fiduciary duties on confidentiality that are owed to the company. We believe that you're in breach of those terms, and these are the reasons why. And again, the gathering of information and evidence there is critical. You might say that they're in breach of the Data Protection Act because they've taken in information that the individuals that gave the company permission to hold would not have allowed it, or indeed the Computer Misuse Act, where they've copied or taken, again, information that they're not allowed to. What you put in the letter is a requirement for undertakings, and what undertakings are confirmatory statements that say that they will and won't do certain things. So you will ask them to deliver up any material that they have that is confidential. You will ask them to confirm that they don't own any more of that information or hold it in any way. You'll ask them to confirm what they have done with the information, who they've provided it to, when and why. And you'll ask that all of that will be contained in a witness statement. In addition, what you'll be seeking, obviously, is your costs of the process as well, and your lawyers, because but for the fact that they'd taken this information, you wouldn't have had to instruct solicitors. Now, obviously, if they refuse to do that and don't provide the undertakings, that can set off alarm bells, because if they've done nothing wrong, then they should be saying, okay, we'll do this, we've not done anything wrong. You'll get a bit of righteous indignation in the process. But if they would absolutely point blank refuse, that is a real big cause for concern. And if they don't provide the undertakings in a specified time frame, and you'd put in the letter a matter of days in which for them to come back to you, because again, remember, time is critical here and moving quickly, then you'd apply for an injunction on notice. So the ex-employee will know about the fact that you're going to seek an injunction, and they will receive copies of the papers, and they'll be entitled to appear before the judge as well. Then you get the same remedies and approach as with the previous injunction. Now, if you have delayed, or if something's come out of the woodwork at a later point, and you think that an injunction's not going to be possible, then you can bring court proceedings and issue a claim for breach of contract. So it's breach of their employment contract, duties of confidentiality and fiduciary duties. And if that's the case, then it would be a situation where you're saying that damages are an adequate remedy, and then the usual principles will apply. So what that means is that you'll be compensated for the loss which the departing employee has caused. So if they've used the information to earn a profit, then you should get a fair compensation for what you've lost. Or if you say that you might have licensed that confidential information to others, then damages would be the market value of what that information would be on a sale or license. Now, in addition to the individual, you might also want to be writing to any new employer if you think that they are making use of the confidential information, or indeed getting your ex-employee to breach their restrictive covenants. What you can do is write to them, and it's what we like to call a keep off the grass letter. So you make them aware of the terms of the individual's contract of employment, and that you are concerned that they are in breach and that you are watching. And you make it clear that if you find out that they are inducing a breach of contract, that they will be liable to you as well. Now, that's a good route to take, because they obviously will have deeper pockets than the employee, and you'll be asking them to provide confirmation that they are not and will not breach or allow the employee to breach the restrictive covenants. So that's a whistle-stop tour through the remedies and the injunction side. And I'm going to pass over to John now, who's going to talk you through the forensics.
just getting my camera and microphone sorted out. Good morning, my name's John Douglas and I'm the Technical Director and Head of Forensic Services at First Response. We're an incident response and cybersecurity company, and we also provide litigation support to law firms. If you'd like to know more about my background or what the company does, you can read my bio on either LinkedIn or on our website. So this morning, I thought it would be helpful to set out some of the ways that a forensic specialist can help you prepare for and how to respond to an employee stealing your data. I've just got this one slide to discuss why it's useful to consider engaging with a forensic specialist, and then a couple of case studies to see how it all ties together in reality. Excuse me. So, forensics in the real world. Well, unlike CSI, we can't recover a car registration number from the reflection in someone's eye in a grainy photograph posted on Facebook. However, we can provide real value when employed correctly. So in that case, what exactly do we mean by forensic? Forensics kind of means different things to different people. My favorite definition is the discovery of truth through the application of science, although it's fair to say that opinions vary on what constitutes truth. How we work with this in the business world, though, is the Forensic Readiness Plan. This is a simple set of policies and procedures which ensures that you've got a reliable collection of information to support an investigation and any follow-on legal actions. What this means in reality, though, is that you're capturing logs and audit trails which hold the right sets of useful data, and that the processes around these are robust. So, for example, they're stored for an appropriate length of time, and they're kept secure so they can't be altered. It's also worth considering how you would prove that to an outside party if you're asked. Training is also really important, not only for HR managers who might be the first to learn of a potential data theft and therefore will likely be the ones managing the internal process, but also your internal IT teams need training too. They need to be aware of the implications of just having a quick look and what that might mean for the integrity of the evidence that you may later need to rely on. It also potentially exposes them to the requirement to give evidence in the event that things go nuclear and the matter ends up at an employment tribunal or at court. One of the most important aspects of the Forensic Readiness Plan, though, is relationships. It's all about ensuring that you know who you're going to engage with in the event of an incident. A good example here is trying to find a plumber early on a Sunday morning to fix a leaky pipe when you don't have an existing relationship with one. Contacts you should consider cover everything from your lawyers to the Information Commissioner's office in the event of a data breach, but also media and communications assistants in case the matter goes high profile. You want a direct number to call for your insurers and, of course, any specialist IT support you might need, like a forensic analyst. And hopes you've already got Nicola and Abby on speed dial. It's always worth taking a little bit of time to establish these relationships before you need them, so that you know who you're dealing with, you know what their associated fees will be, and you know what they need from you so that you can prepare that in advance. So, how does support actually help? Well, there are a number of immediate benefits. Key amongst these is independence. The various key actors on the other side involved in the process are more likely to take the findings of an independent forensic specialist seriously than if they were produced by your internal IT team. It's also the case that if the matter proceeds to a tribunal or to court, then an independent expert's findings will be given more weight than those produced internally. Well, to a point anyway. Probably the biggest benefit you'll see, though, is a result of experience. A forensic specialist does this kind of work every day. They're familiar with the technical means that people use to try and hide data, and also, more importantly, hide their actions. Technology moves at pace, and it's only by doing this type of work every day and by being familiar with the specific tools required, many of which cost tens of thousands of pounds, that the potential artifacts and evidential trails become exposed and any deception is uncovered. Another big advantage of having the support of a forensic specialist is to play devil's advocate from a technical perspective. So that's not just pulling apart fanciful technical explanations from the employee in an attempt to bluff a non-technical HR manager, but also to provide plausible alternative explanations as to why those artifacts may be present. Lawyers greatly appreciate knowing where the landmines are buried prior to contact with the other side. It saves a great deal of embarrassment all around. So given all of that, what's the forensic advantage? One key point is the output of the forensic process, a formal technical forensic report. This provides a compelling narrative of who did what, with forensic artifacts presented and exhibited. It's very often the case that a technically literate employee who is used to running rings around their co-workers technically often become very sheepish in the face of a forensic report that clearly sets out that they downloaded these files to their workstation from the corporate network on such and such a date, copied them to a USB drive of this make and model, and then deleted the files from their workstation, which, by the way, we recovered. Often this is enough to encourage the employee to put their hand up, say sorry, sign an undertaking to delete all and any copies of the data that they may have, and be on their way. Another advantage you get from having a forensic specialist on board is a technical person equally comfortable talking bits and bytes to your IT team or evidential artifacts to your legal team. A good forensic specialist is familiar with working within a legal framework, understands the jargon, and knows what your legal team need to ensure a successful outcome. And in the event that you do end up at a court or in tribunal, a good forensic specialist will be comfortable in giving evidence, even under quite robust questioning. We get specialist expert witness training for this very reason. So that's the boring bit out of the way. Now let's have a look at a couple of quick case studies that show how this played out in a few recent cases I worked on. First up, the case of the missing books. So we were called in to assist a long-established and family-run rare book firm. This shop held books like signed Lewis Carroll first editions and some really old books that were valued in tens of thousands of pounds each. It's fair to say that the elderly husband and wife team who ran the store were not particularly technology literate. They could deal with email, but that was about their limit. They had hired a young man who had some IT skills, and for the first few months, everything seemed to be going really well. Then they noted a few books started to go missing. At first, they assumed that they were simply lost in the jumble of what was quite a disorganized space. Over time, though, more books started to go missing, and the owners were sure that their latest staff member was responsible. We were asked to see what we could find out after one of the owners was tipped off by a client that books he had mentioned earlier as being missing were now appearing on eBay. Analysis of the staff member's computer showed no obvious signs of anything untoward. However, we discovered he was also running a VMware virtual machine. This is a kind of hidden computer within a computer. Inside this virtual machine, we found a rich internet history of visits to eBay, deleted scans and digital photographs of books, along with a large number of deleted emails answering questions from potential buyers. When initially questioned, his defense was that his eBay account had been hacked and that he hadn't signed into it for months, so this must have been somebody else. When shown a printed copy of one of his emails, obviously from his account, he replied, "But I deleted that." He was later handed to the police and convicted of theft. So the next case study that I wanted to look at is around aerospace designs. We were assisting a UK aerospace company that produces items for the defence sector. And as you can imagine, there's quite a culture of secrecy surrounding their work. We were examining their firewall logs as part of a routine security audit when we discovered a block of traffic destined to a country unfriendly to the UK. Further examination uncovered many similar blocks going back several months. So the IT manager and I decided it would probably be prudent to put deeper monitoring in place, and within a few days, we'd gathered a tranche of data implicating 3 engineers who were all involved in a highly sensitive area of the company, who all appeared to be working in concert and communicating with this foreign nation using their private Gmail accounts. At this point, though, we didn't know what the emails contained as we couldn't read the encrypted content, but the metadata present in the headers of the emails was clear. We presented this data to the company's general counsel and to the security manager, and then helped prepare supporting documentation to obtain a civil search order. Given the nature of these engineers' work, the Ministry of Defence was also informed, but at this point, they left it for us to pursue at a civil level and would pick up any pieces left over later. The searches conducted at the engineers' homes uncovered a huge amount of intellectual property belonging to the company, some of which was protectively marked secret. Their home computers contained complete copies of their email conversations with the foreign aerospace company and indicated that they were all about to resign the following month and head overseas to their new jobs, where they would help the local engineers understand the manufacturing process in detail. They were each promised salaries in excess of 200K. They were later charged under the Official Secrets Act, whilst at the same time, the company took all three to court for breach of contract. This resulted in all three having to sell their houses to pay their legal bills and the compensation owed to the company. As I understand it, it left all three bankrupt and unable to work in the engineering sector. In an interesting footnote, the Boeing aircraft company in the United States was hacked about 6 months later by what has been described as a nation-state intelligence service, and their copies of the same design information were exfiltrated back to the host country. No prizes for guessing who. So finally, if we still have a few minutes, I've got one more case study that looks at things from a slightly different angle. I was working at a client and assisting on another matter when one of the IT team asked if I could have a quick look at a strange problem. A new staff member was having trouble opening her files and the IT engineer wasn't sure why. When any of the documents were opened, were clicked or tried to be opened, they prompted for a password. The user had tried every password she could think of, but nothing seemed to work. When I looked at one of the Word documents with a forensic tool, it was clear that they were encrypted using Microsoft's data loss prevention technology. This is an enterprise solution and one I knew that my client wasn't using. So digging in a bit further, I noted that a digital signing certificate for a well-known American bank was also embedded in the document. When asked about the provenance of the documents, she admitted that she had copied them from her previous place of work and robustly defended the action because they were, in her mind, her documents. She had created them when she worked there and she was going to keep them. The USB stick contained many more documents, which it turns out came from a number of other previous roles at other companies. Her manager and the HR manager both agreed this was dangerous territory, and the new starter was then told she had failed her probation and dismissed, all on her first day. To avoid any additional comeback from the previous employer, the company quietly advised the previous employer of the data theft. And this turned out to be just as well, as the other company had registered the fact that somebody had tried to remotely open these documents on an unauthorized computer, and they were just starting to investigate this potential data breach themselves. It's an interesting case that highlights the dangers to an organization, not just from an employee who might steal your company data, but also from an employee joining who has no idea of the jeopardy they're putting themselves in, but more importantly for you, the underlying risk to the unwitting recipient company. Well, that's all I wanted to say. I'll hand back now to Nicola for the Q&A and look forward to answering any technical or forensic-oriented questions that you might have.
Great, thank you very much, John. That was really, really interesting. Great to see putting the forensics into practice. So we've got a lot of questions that have come through, lots of keen people out there, which is great to see. I'm just going to see, let me have a quick look. Oh, I think this is one for you, Abby, if this is okay.
Yeah.
Somebody's asked, what's the difference between confidential information and trade secrets? And is there a time limit on how long certain information is classed as confidential?
Yeah, that's a really good question. So trade secrets are viewed as much sort of much more confidential, if you like, than what the courts describe as mere confidential information. So they're things that are typically known only to the business with real commercial value because it's so secret, and subject to reasonable steps to keep secret. And it's that latter part that I think really separates out trade secrets from other confidential information. And you have those common law obligations and protections in relation to both confidential information and trade secrets, but also trade secret regulations that are a separate way of protecting trade secrets as well. So different ways of protecting trade secrets, but certainly a level above other confidential information. And really, I think there has to be significant steps on a business to keep that information, that secret information, very secure. So it may, for example, only be known to a couple of people or a handful of people within the organisation, and really subject to a lot of protection. Confidential information does have a lifespan. You know, I think if you were looking at sales forecasts from 4 years ago, for example, they may not be confidential now. So there will be, as the passage of time goes on, it is likely that confidential information becomes less confidential because markets move on, businesses move on. So yes, there is a lifespan, but it's not a one size fits all. I think it depends on the type of information that we'll be looking at.
And I think it's fair to say on that, isn't it, Abby, that collect everything, take everything, and then we can help, or your lawyers can help take a view on whether it is actually confidential. Because I think I've had cases where there have been pricing lists and information around sort of percentages of commission paid, and that hasn't changed for 5-6 years. So actually then it is still confidential. Whereas if it's been superseded by a new business arrangement or different rates, then actually it's not going to be confidential anymore. So as you say, it's not a one size fits all approach. A question for me, I think, the potential costs of taking the matter to court. I'll give you a lawyer's answer, which is how long's a piece of string. But to give you kind of an indication, injunctions aren't cheap because, well, they're important. They are an emergency situation, and it takes a lot of work to pull them together, working very, very quickly. You have to produce all of the court documents, you need to instruct a barrister, you need to produce the witness evidence. And that's where, going back to what I said before on a number of occasions when I spoke previously about collecting your information, if you can present a lovely little bundled package to your lawyers, if something does go wrong, it's going to save a huge amount of time. And also, if you've got your IT and the right people on board, again, it's not going to be a massive fact-finding mission. You can literally tie it up with a bow, give it to your lawyers and say, please help us. Now, when you go to seek an injunction, it can be anything between 15,000, 20,000 to 100,000, really depending on how detailed it is and how much information is needed and how many people you need to involve. If you need forensics involved to look at what's happened and John comes on board, you've obviously got those costs together with barristers' costs together with lawyers. So again, as I say, this is an urgent injunction. It's an urgent remedy, and it's absolutely there to protect the business, where if you don't do it, you're going to suffer immeasurable loss. A question for you, John, I believe, because I think this is what are the most common methods that an employee uses to copy or steal data?
Okay, so yeah, employees will kind of take whatever measures they've got available to them. That can be anything from using a USB stick, emailing data to their home email address, to a private email address. It's usually the case that companies now have kind of got protections in place and prevent the use of USB sticks and things of that nature. But for smaller organizations who maybe don't have that infrastructure complexity, all kinds of different options are available. If the employee has a laptop, for example, they may simply take the laptop home and be able to copy the data directly onto a home network. We often see people using internet file sharing sites like Dropbox. That's pretty commonplace. These kinds of things can be mitigated with firewall rules at the company to prevent data being, exfiltrated that way. In more sort of sensitive areas, like the aerospace company I mentioned earlier, for example, where they were very secure and had everything locked down quite tightly. Some of the engineers there were taking photographs of confidential material using their mobile phone. Now, obviously, that's very, very difficult to prevent, and detect. It's just not possible unless you've got some way of being able to maybe using a civil search order to seize their mobile phone and do an examination that way.
Great, thanks, John. And yes, I completely agree. I think that's absolutely right. Mobile phones are one of the, well, they're are a big asset, but also a huge curse to most businesses, because you often don't know what's on it. And going back again to something that Abigail mentioned around making sure you've got the right policies in place within the business, you can have policies there where people use personal mobiles to make sure that you have got the right to access those at some point. And I know a lot of businesses these days, you don't necessarily have a separate work mobile. So then there's a lot that's on the personal mobile of the individual. So that's something that's always worth bearing in mind. I think another couple of questions, if we can. One for you, Abby. Obviously, we talked a bit about confidential information and trade secrets, and that's generally in writing, but what do you do if an individual leaves? What can you do about the information that's in their heads?
Well, not an awful lot if it's simply in their heads. It's the point at which they use it that we'd be looking at taking steps to try and prevent them using it. So reminding them of their obligations is always a very, very helpful thing to do when they leave. So, maybe perhaps when you're acknowledging resignation, or generally when they're leaving, a leavers letter to draw attention to the provisions in their contract that survive, so that they're aware of that. It's difficult because if you've got someone who's dealt with, knows clients' numbers off by heart because they've dealt with them for 15 years, they can't just automatically forget it. But you can use what's in your contracts to stop them from using it for a period of time.
And so even if you can stop them, it's only ever for a set period of time, isn't it? So with the restrictions, if you've got 3 months, 6 months, 9 months for somebody that's a bit more senior, I guess my question is, you need to act quickly, don't you, to make sure that you get the maximum protection from any written contracts that you have?
Yeah, absolutely. Yeah.
Great. I think one more question for you, John, if that's okay. How long does it take to create a forensic readiness plan? You talked about that, and what would be involved in that process? I think it'd be helpful to give a bit more detail on that if you can.
Sure. So it depends a little bit on the complexity of the company and the infrastructure that's in place. Typically, though, it's probably just a couple of days of consultancy. So working quite closely with the IT team and the HR team. It ties very closely into crisis management and incident response in many respects. So the forensic readiness plan is really focusing on making sure that logs on servers, especially where users are authenticating to a server, that the settings are switched on for the logs so that we are capturing the right set of data and holding it for the right period of time. Rather than go through chapter and verse here, it's probably going to be easier if people maybe contact me through you, and I can have a chat with them directly, and we can set out precisely what's needed for that environment. Great,
brilliant. Well, I think that's all we've got time for today. Thank you very much for everybody who's joined us. All three of us remain available to you. You've got our details on the screen there. If you'd like to call us, if you've got any questions, feel free to email. If there's anything that we haven't discussed that you'd like further detail on, we're always happy to take calls. And thanks again for joining us today. Have a good rest of the day. Thanks.
Thank you.
Bye-bye.